believe most of us have heard the outcome of Mazi Nnamdi's case today, the court case today, where the judge overruled the no case submission by Mazi Nnamdi, ruling that he must enter a defense, insisting there is no material evidence of extraordinary rendition as claimed. So here I want us to just examine the ruling in the light of criminal law and constitutional justice. First, the doctrine is clear. Due process is the foundation of every criminal trial. The Nigerian Constitution, under Section 36, Article 1, guarantees that no one shall be deprived of liberty except in accordance with the procedure permitted by law. What happened to Mazi Nnamdi, extraordinary rendition, is an unlawful abduction, a violation of extradition protocols or procedures under international law, and a breach of the Extradition Act E25 LFN 2004. Once an accused person is forcefully brought into jurisdiction without lawful procedure or process, the prosecution is tainted with illegality. Second, in criminal jurisprudence, there is what is called the doctrine of fruit of the poisonous tree. This means that evidence or proceedings obtained through illegality cannot stand in court if the arrest itself was unlawful. Then every charge and proceedings flowing from it is legally defective. That is a well-defined principle in criminal law. It stands on its own. It remains undisputable to be observed in criminal case. By insisting that no material evidence of rendition exists, the court is ignoring a well-established principle that the manner of securing jurisdiction is as important as the charge itself. Thirdly, criminal law demands that the burden of proof, the onus probandi, lies squarely on the prosecution under Section 135 of the Evidence Act 2011. It is not for the defendant to prove how he was abducted. It is left for the state to provide the evidence to prove that they followed due process in arresting Mazi Nnamdi, in bringing Mazi Nnamdi to the court. It is for the state to show that his presence before the court is lawful and procedurally compliant. By shifting the burden of proof to Mazi Nnamdi, the court risks violating the principle of presumption of innocence as guaranteed under Section 36, Article 5 of the Constitution. Fourthly, extraordinary rendition is not a mere technicality. I want you to understand, extraordinary rendition is not just a mere technicality. It amounts to abuse of process in criminal procedure. Once abuse of process is established, the court is duty bound to strike out the proceedings because justice cannot emerge from illegality. Otherwise, Nigeria is about to set a precedent that the state can commit crimes in order to prosecute alleged crimes. I must tell you, that is what is called miscarriage of justice. Finally, the stakes here goes beyond Mazi Nnamdi. If this illegality is overlooked, then no Nigeria is safe. Any citizen can be abducted without extradition, without due process, just dragged before a court and told to defend yourself. That undermines the rule of law and replaces it with rule by force. So as we approach October 8th, the question is simple. Will Nigeria uphold the sanctity of criminal justice, or will it legitimize illegality? A lawful society cannot build conviction on unlawful foundations. The only true justice is one that respects due process, the Constitution, and the principle that no trial can be valid if the pathway to it is unlawful. True justice must follow due process. Anything that goes against the due process violates the law itself. So I just say, let me throw more light over this ruling today. Hence they say there is no physical evidence to show that Mazi Nnamdi was extraordinary rendition. That term is not just technicality, it is a principle. It's something backed with the Constitution. It's not just a mere phrase. It amounts to procedural violation. Once the procedure is violated, justice cannot be established on violated procedure. That's the simple fact. So let us keep our fingers crossed and see what the court will rule come October 8th for the final judgment over this very matter. Thank you so much. and God bless you. I would like a situation. If you have a different view over this very matter, I want you to share it in the comment section so that we can reason it together. Let us iron it together. And if it is your first time coming across my videos, I plead with you to follow my page and subscribe. God bless you.
South Federal Constituency, the National Assembly. I am the primary representative of Mazi Nnamdi, Kanu. We are very disappointed in the ruling of the court today, where especially the court took a position that the extraordinary rendition was not going to be part of the consideration today. But he, however, to be fair to him, said if we can prove that there were extraordinary rendition, then that would change his consideration. So we are coming back. I've been assured by the lawyers that they are coming back to show that proof. One, the issue of jurisdiction. We will now know whether this court has jurisdiction or not. That's number one. Then number two, there seems, I keep saying it, there seems to be two sets of rules in this country. One for the Igbo man and the other one for every other Nigerian. Where every other Nigerian gets a reprieve, the Igbo man would not get a reprieve. You look at even the issue of the health situation of our brother. There have been many circumstances where people have been given opportunities to go and seek medical care, yet Nnamdi Kanu is denied. Even the president, at every consideration, the president goes overseas to take care of himself. He doesn't even subject himself to Nigerian medical attention. So it is very wrong for them to deny Nnamdi, who the doctors have laid clear evidences that he's having insufficiencies, organ insufficiencies. And what is the government waiting for? For him to die? And then the circumstances will now be brought up again? So, but for the Igbos, I'm more disappointed with the Igbos. The political leadership of the Igbo land, the spiritual and otherwise concerned, are keeping quiet, extraordinarily quiet, on the issue of Mazi Nnamdi Kanu. Especially when it is shown that when it concerns to others, especially in the north, the government is negotiating with terrorists, non-terrorists, dressed up who with guns and various ammunitions, and yet they have not proved that Nnamdi Kanu is a terrorist. So it is up for Igbos to now rise up to ensure that we come in total defense of our brother and ensure that, especially in the administration of criminal justice, that he is not being marginalized. So Igbos should rise up for once and to say that all this spectacle, that enough is enough.
Excuse me. Nigerian Medical Council, now listen. The Nigerian Medical Council, you people examined Mazi Nnamdi Kanu on, that was 3 days ago. Yes. And the report will have it where you people said that the report given by AAJ did not even capture the entire health condition of Nnamdi Kanu. You discovered more. That you people should not doctor that report, because court has ordered that you people should bring that report to court. We know what is happening in Nigeria, because now that it involves Nnamdi Kanu and the Igbos, they may force you people or may intimidate you people, because we learned that DSSS are even trying to intimidate eminent Professor Emeritus, Professor AAJ, who has been a Provost College of Medicine, University of Nigeria, who has been a dean. Then his medical record is there, and somebody that is not even a consultant is questioning the report given by AAJ. Now the team, you people constituted, met Mazi Nnamdi Kanu, that was 3 days ago, at the DSSS, and Nnamdi Kanu subjected himself. We have that report. That report, as people have it, provide it in court. Having said that, now what gave rise to this particular issue of medical council is the petition I personally submitted against Dr. Mohammed Nasiru from DSSS, the doctor that never examined Nnamdi Kanu, but he decided to depose falsely on oath. 37 paragraph affidavit. I submitted that petition. It was on that basis that Attorney General ordered the medical council to constitute a different board. We have been following it up, and that petition must be heard. And the Dr. Nasiru should be, with his license as a medical doctor, if he is, should be withdrawn. I, Chief Barrister Maxwell Opera PhD, is submitting. It should be there. Just like what Honorable said, I'm highly disappointed to my fellow Igbo people. Nnamdi Kanu is suffering this because he's an Igbo. Yes. We must say it. Yes. Had it been that Nnamdi Kanu is from the north or from the southwest, he wouldn't have been there by now. And everybody's keeping quiet. Both the religious leaders, both the political leaders, both those in diaspora, nothing is happening. You feel that you see Nnamdi Kanu that is this. I'm not disappointed. So this is the judge said that. The judge said that he's not aware of extraordinary rendition. We are taking it like that. We are going to bring a formal application. We are going to attach all the whole judgment given by even Kenya. The country said that yes, our country did not do well. Now Malami is he has turned activist. The Malami that comes in, he has turned activist. He's now in opposition. As you are doing anything, remember that you cannot be in government forever. Yes, tomorrow. That is my message to you. Thank you. I want to say something.
And finally, hold on. And finally, to conclude everything, it is despicable. We take a serious exception to the fact that the doctor that examined Onyendu Mazi Nnamdi Kanu, emeritus professor of medicine, well renowned all over the world, that someone from the government side reported him to the Nigerian Medical Association, and he was summoned to Lagos to face a panel, all because he returned the truthful diagnosis on Mazi Nnamdi Kanu. So this persecution knows no bounds. We are wondering when they are going to come after the lawyers as well. They are now going after the doctors. The idea that the doctor, the primary physician for Mazi Nnamdi Kanu, chosen by him, is being intimidated by the government is despicable. The primary goal of everybody should be the health condition of Mazi Nnamdi Kanu, not the intimidation of anybody that brings the truth before the authorities. The doctor is a witness of truth, and on that truth we shall stand. Mazi Nnamdi Kanu's health condition is very paramount, and everybody should go out there and talk about it. You cannot stand trial if you are not healthy. Thank you very much.
I want to say something very important, because I'm thinking that this ruling favors us to some extent. The judge said that there is no evidence of extraordinary rendition before him. That is the case of jurisdiction. He has said it. Yes. So we are not entering defense until the court determines it whether he has jurisdiction or not. So the court has given us a hint. We are going to file it and bring the evidence that the court has. Once it discovers that the court has no jurisdiction. So let us go with hope in our heart that the door is not closed. We are going to do it.